We are running out of time, so I'm not going to give you the break that you might like, and I'm going to hit the ground running. I have carefully watched all of the earlier moderators, learned from them all, but I think I'm going to use as my role model Judge Rosenthal, because she was politely, genteelly, iron-handed. And we need to be this at this point because we're running out of time. Therefore, I am going to ask you all to tolerate me and hold your questions to the end. Otherwise, I'm going to be in the position of giving the microphone to Judith Resnik with 1.5 minutes to go, and I know she will hold me accountable if I do that. Instead, this way, if we run out of time, you can all hold her accountable, but we'll take the questions at the end. Our very first speaker is going to be Elizabeth Cabraser. I'm going to introduce Elizabeth very briefly by saying that she is simply the busiest lawyer in the world as she shuttles between General Motors ignition to Volkswagen to 10 other cases. Indeed, we're getting to the point where I think the Antitrust Division has to start investigating Elizabeth because she may be a walking violation of Section 2 of the Sherman Act. Section 2 of the Sherman Act forbids attempts to monopolize, and we're at that precipice. Elizabeth, I've just made a serious allegation. You have your Miranda warnings, but with that advice, please tell us how you think aggregate litigation should look for the future.
Well, I think it does, after taking refuge here for the day from the wonderful world of defective automotive products, I can say that I think the future of group litigation looks very bright. And that doesn't mean that I haven't been paying attention. I've been paying a lot of attention as a practitioner, utterly dependent upon the ability of judges to innovate and adjudicate, and the thinking of those in the academic community on how we should do what we do. At this point in my career, I have much more past of group litigation than I have of future group litigation, but I'm looking forward to that future, what remains of it, very much. And you may think this is an odd thing to say, given some of the discouraging things that have been said, but to me, to quote from that wonderful cultural resource, the band Timbuk3, "The future's so bright, I gotta wear shades." This is an unprecedented period of judicial innovation in group litigation. Judges, primarily through the gathering mechanism of multi-district litigation, through what I at least see as at least a minor resurgent in class actions, and through other methods being tried, some for the very first time, in terms of group trials, bellwether trials, consolidations, master complaints. Judges are innovating in ways that are beginning to recapture for all of us the economies of scale that were the promise of aggregate litigation. The promise has yet to be fully delivered, but the point is this: we are not going to eliminate mass harms. We are going to continue to need mechanisms, public, transparent, judicial, in-court mechanisms to address the mass harms that people in this country will continue to suffer. We can't go back to where I started my career, which was the ideal of the individual jury trial. One at a time, a day in court, all day, every day. People have not lost the need to have attention and respect from the court system. I think people need that more than ever. But if you think about it, the most popular courtroom show on TV is Judge Judy, and there are no lawyers in that show. It's just the judge. That's what people want from our system. They want attention and respect from the decider. That's why, for example, Ken Feinberg is so successful in some of the programs he does, because he is essentially in a quasi-judicial role, and he is paying attention and he is giving individual respect, and he's doing the best he can within the limited constraints of a particular program or protocol to do individual justice in a group context. That is something that is an ideal embodied in Rule 23, the judicial control and supervision over the class counsel, the selection of class representatives, and essentially the fiduciary relationship to the class members. And that is something that MDL transferee judges do every day in the mass tort actions that they oversee, to make sure that the cases that come before them are not just cases, the people are not lost, they make sure the people are real, they make sure the lawyers are being loyal agents, and partly through technology, they make sure that people can follow along the process. Every MDL I think that I'm involved in right now, the judge has a website. And the transcripts and the orders and the schedule are posted on a same-day basis, and every one of my clients and every other plaintiff in that litigation has instant access to what's going on. The proceedings are public, and judges are very attentive in terms of outreach to the real plaintiffs. And MDLs are, like Lipton iced tea, brisk these days. 5 years is a very long time, and these days, only the largest MDLs are of that duration, and a tremendous amount is accomplished. There is a need to more closely align the efforts and loyalties of attorneys and their clients. Attorneys are just the gateway for clients to get before the court. My clients care much more about the judge than they care about me, and that's right. My job is mostly not to get in the way. My job is to make sure that their claims and their issues are presented in a way that gets an appropriate amount of judicial attention, that has to be worth that amount of judicial attention. But what my clients care about is that someone listened to them, not me, someone listened to them, someone paid attention to them or to people just like them, and thought about the claims and the issues. And that, as many have said today, is as important, if not more important, than the actual outcome. And I will say this, my clients care about injunctive relief, very much so. It's not an all-cash world for them. They do care about the deterrent effect of their claims, and I think those have to be preserved. With respect to attorney's fees, I think we're just at the beginning of judges taking the control that they've always had as a matter of inherent authority. You don't need a quasi-class action to regulate the conduct and the fees of the lawyers that appear before a particular court, and to try to make sure that the economies of scale that are supposed to inhere in group litigation are delivered to the parties on both sides of the case by appropriately regulating and controlling attorney's fees. We're just at the beginning of being able to do that. I don't think it needs to be punitive. I don't think it needs to be restrictive, but I do think it has to be proportional. One of the best ways to ensure that attorney's fees are proportional is to make sure that there are economies of scale, that it is more cost-effective for any lawyer in an MDL to represent a large number of people, to not have to charge a third or 40% to hundreds or thousands of claimants. There's something wrong with that, but it often happens because it's not paid attention to, judges have other priorities, and sometimes aggregations are simply that, aggregations, rocks in a bucket, where every claim has as high transaction costs as if it were an individual claim. And that's the biggest challenge in group litigation, is to get back that economy of scale, because we don't have the judicial resources to give every person her own judge for a day. We do have the judicial resources to pay attention to groups of litigants and to give a proper measure of respect, but that means that other processes are going to have to be made much more efficient. And I think some of the techniques that Judge Hellerstein described are exactly what other judges are doing and what judges should be doing more of, and frankly, what lawyers have an obligation to develop, design, and to promote in the cases that they bring.
Thank you. We're now going to have some PowerPoint slides for the next three speakers, and we've got to get those turned on. Okay, thank you. The next speaker deserves no introduction, and will get none. At every panel that I've gone to in recent years, there's always one person who addresses globalization and the topic at hand. The minute he begins to speak, eyes glaze over all over the room because people say, this is remote, this is futuristic, this has nothing to do with my problems of managing my docket next week. That may be generally true. I'm the person on this panel who is addressing globalization, but I'm not addressing the future. I'm addressing the last 6 weeks because there have been fundamental changes in the pace at which aggregate litigation is sweeping across Europe over just the last 6 weeks, and that pace is going to continue. I don't know what the future is. There are rival scenarios, but we're moving very quickly towards something. Now, I'm using the term entrepreneurial litigation. Let me define this very quickly as simply litigation in which the attorney is really a risk-taking entrepreneur, both financing the action and managing the litigation, almost always having a much larger stake than any claimant in the litigation. In the U.S., this domain includes class actions, derivative actions, qui tam actions, and of course, increasingly, consolidated mass tort proceedings, all right? Conversely, around the rest of the world, entrepreneurial litigation is basically unknown outside the United States, with partial exceptions for Australia, Canada, and Israel, okay? In large part, this is because entrepreneurial litigation is thought to depend on three critical criteria, which seem to be present mainly in the United States. Criterion one is broad claim aggregation. Not the existence of a class action, but rather broad claim aggregation, which can occur in consolidated proceedings as well. Okay. Second, we need contingent fee financing of some form. This offers both high incentives to plaintiffs' attorneys, and it allows small claimants holding negative value claims to be able to compensate their attorneys, because otherwise they wouldn't pay up front. And third, this system of entrepreneurial litigation needs immunity from loser pays fee shifting, and most of the rest of the world has loser pays fee shifting, while the United States has the American rule. Europe has none of these elements, and thus for some time commentators have doubted that aggregate litigation or entrepreneurial litigation can move to the European theater. And indeed, members of this panel have suggested that unless the European systems move towards an opt-out class action and at least some tolerance for the contingent fee, we would not see aggregate litigation spread to Europe. Notwithstanding the advice of all these American academics, Europe has politely disdained that advice and has not shown any interest in moving to either of those procedural innovations. Nonetheless, the American commentators who say the American system can't move to Europe may have missed something, because there seem to be alternative means by which all of this can move to Europe. And let me ask you to consider this matrix up here. In the United States, we have the opt-out class action, and we have mass consolidation, two alternative means towards claim aggregation. In Europe, we don't really have either, but we're moving towards a system in which consolidation occurs through active solicitation by a new profession in Europe, claim aggregators. And I'll tell you who they are in just a bit. These claim aggregators are moving together fairly large players. In Europe, share ownership is very consolidated. It's a different structure of share ownership, and there are lots of consolidated holders. A small holder may be holding 20,000 shares in Europe. It's easier to aggregate people who have 20,000 shares than people who have 100 shares, but we're seeing that happen. That's the first technique. Claim financing, we have the contingent fee in the United States. In Europe, we're beginning to see the active use of third-party funding based on a percentage of the recovery formula, which is a contingent fee, but not a contingent fee paid to the attorney. It is a contingent fee paid to the financier, the funder, and in Europe, there is no regulation of the funder. It's only regulation of the attorney as a professional. So we can have contingent fees as long as they're paid to the third-party funder. Finally, protection from fee shifting. In the US, of course, we have the American rule. But we're now seeing in Europe the development of loser pays insurance, under which D&O insurers will also insure the party that is the plaintiff's attorney and has the possible liability for the loser pays fee award. This insurance is expensive. I'll tell you how expensive in a minute. It makes the whole system very expensive, but it does allow a system under which the claim can go forward with complete assurance that you're protected from any personal liability. Now, let's go through each of these elements a little bit more closely. In terms of claim aggregation, the opt-out class action is the American rule. To the extent that Europe is any kind of class action, it's basically the opt-in class action, and even then there were additional restrictions on most European class action systems. But what device have they found? Under Dutch law, there's an interesting device called the Stichting, which the American press inaccurately keeps translating as foundation. But it's really a limited liability legal device. It exists for a very specific purpose, and the purpose might be litigation. Basically, it functions as a means by which to separate ownership and control. By transferring your legal rights to the Stichting, through its board of directors, gets to resolve the litigation, settle litigation, but not to get the proceeds. The proceeds still go back to people who own the shares. These have recently been used in several major European legal proceedings, okay? Now, it still takes an entrepreneur to put all of this together. The entrepreneur has to assemble aggrieved investors, getting enough that you have a viable claim aggregation, then third-party funders who are going to finance you and pay for the cost of the insurance, insurance companies to give you that insurance against fee shifting, because it's still a pretty uncharted legal terrain in terms of what all this was going to amount to. And you're going to need soliciting agents who will go out there and find the shareholders. And you're going to need local law firms who will be paid on a regular hourly basis and get no contingent fee, but will report to the people organizing all this. Who's organizing all this? Who is that innovative and entrepreneurial? Only our old friends, the American plaintiffs' law firms. And who has been doing this? The leading example I want to tell you about is the Fortis case. Fortis was an iconic term in Europe because it was one of the largest banks that failed. It was a major problem for both Holland and Belgium, and it had to be bailed out by all of the low-land countries, okay? Its shareholders sued. They sued first in the United States. They sued before the Morrison versus National Australia Bank case, but it was dismissed even then because even before Morrison, there wasn't enough conduct in the U.S. to justify litigation in the U.S., and the judge ruled that there was no subject matter jurisdiction in his court. Okay, but the plaintiffs' lawyers continued their contact with the principal investors, both U.S. and foreign investors, and they formed two Stichtings, one in Holland, one in Belgium. I have their names up there, and these Stichtings assembled quite a lot of stock. This litigation went on in both countries, Belgium and the Netherlands, for a substantial period of time until the defendant, including all the insurers behind the defendant, decided it was time for a settlement. And the settlement form they used was a special Dutch statute that permits only a settlement class action. It doesn't have a litigation action, just a settlement class action is authorized, but there had been litigation, and the survivors of Fortis and its successor, Aegeus, decided they wanted to settle. Consolidating all these efforts were two well-known American plaintiffs' law firms, Grant and Issacharoff, located in Delaware and New York, and Kessler, Topaz, Meltzer, and Sheaf, located in Philadelphia. Grant and Issacharoff had originally done this years before in a major settlement of the non-U.S. claims against Royal Dutch Shell, and they had gotten a $381 million settlement about 7 or 8 years ago. Okay, that was the first precursor, and that's why they were familiar with that technique. Now, they then found two additional new players. Demonor, a Brussels-based firm that specializes in representing minority shareholders and assembling them, and VEB, which is the standard Dutch shareholders association. Now, putting all this together, they came up with a solution which they have presented before the Amsterdam Court of Appeals. This settlement, agreed to by the defendants, is for $1.337 billion. This is off the charts in terms of the prior European experience because it is 4 times bigger than the Royal Dutch Shell settlement, and the Royal Dutch Shell settlement was 10 times bigger than anything else they had previously seen in Europe. So a couple of order of magnitudes up. Now there's some interesting quirks in this settlement. The settlement is going to compensate active shareholders more than passive shareholders. That's not done in U.S. class actions. It's a kind of a per-share basis. But it is the U.S. reality, because in the U.S., large institutional investors almost always today opt out of the class action and settle at a much higher rate. So we're getting in one step about what happens in two steps in the United States. Am I saying that's fair? No, I'm just saying it is a parallel to what actually happens in the U.S. Okay, that's the first case, Fortis, and that has shocked all of Europe, and it's got a number of American plaintiffs' law firms looking how we can get on this kind of gravy train as well. The next case that's assembling now is Volkswagen. This is not the U.S. claims of shareholders, but this is the claims of shareholders in Europe, or claims of U.S. shareholders who bought the shares in Europe pursuant to trading on the Deutsche Börse. Now, again, it's the same two law firms in Germany, Grant and Eisenhofer and Kessler Topaz. They have brought litigation in Brunswick, Germany, and here are the players. They have a third-party funder, which is basically an Ireland-based third-party funder. They have gotten an insurer that will give them insurance against loser pays liabilities. I am told, this was an estimate, don't hold me to this being precisely accurate, this insurance costs between $4 and $5 million. We're not talking about nickel and dime elements here, but it's paid for by the third-party funder, so that none of the institutional investors who are represented in this action, and there are some 278 U.S., European, Asian, and European institutional investors in this litigation, none of them face liability for loser pays, at least so long as the insurance is adequate. None of this offends the European prohibition against contingent fees, which applies only to attorneys, because the American law firms are not practicing law, they're never going to court, but they have retained and hired the German law firm, which will be paid on a strictly hourly basis. Okay? This suit that I'm talking about, let's go back one. This suit, this suit was filed in about March 16th, so it's very recent, and what's going to happen? Well, I think we're now looking at two rival scenarios. Scenario one, which Europeans are already beginning to worry about, is that we're seeing the second Normandy invasion. As American plaintiffs' lawyers invaded Europe, first settling in the Vivendi case in France, now carving north, rushing through Amsterdam and into Brussels and now into Germany, and no one has moved this fast since General Patton a few years ago. That's alternative one. Alternative two is, and this happened in Napoleon also, there just might be a Waterloo out there. We haven't seen yet how effectively the empire can strike back, but empires do have a way of striking back, and although this litigation has been brought in a German court, the real game plan that they have, if I understand correctly, is they're going to litigate in Germany until they show the case has some staying power and can't be dismissed, and then they want to do a collective settlement back in the Netherlands, because only the Netherlands has a collective settlement action that can bind everyone. All right? That's the game plan. Other American law firms, Bernstein Litowitz, which is the largest plaintiffs' law firm in New York, are collecting claimants in the Netherlands. They're not suing in Germany, but they're waiting for that collective resolution that they think is going to come in the Netherlands, and then they want to join in. So there's already competition on this new playing field among American law firms. What's the future going to look like? My own view is that if this is successful, the Europeans aren't going to need the American law firms for long. They can find out how to do this on their own, but at the outset, the boldness and the scale of all this took real entrepreneurs, and the American firms moved into that void very quickly. Okay, evaluation of all this. This is the other litigation. Okay, this is an extremely expensive approach. The third-party funders aren't getting the 1/4 to 30% plaintiffs' lawyers get. They want half the settlement or more in these cases. And remember, they're putting a lot of money in. They're not only paying the cost of the litigation, they're paying that $4 or $5 million for loser pays insurance. So it's going to be very expensive. We're not talking about a system that's protecting negative value claimants. The small claimants here are people who are customers of a big bank, and the big bank has 20 or so accounts of 20,000 shares each, and they're working to put them all into this class action settlement. So I'm not saving the little people, but we are seeing a system develop that seems to be bringing entrepreneurial litigation to Europe. And these last two, Fortis and Volkswagen, are giant cases, but before them, Vivendi, Royal Bank of Scotland, and several others did show that this system beginning to evolve, and now it's bloomed in full scale, in both Fortis and the Volkswagen litigation. Okay, these cases are being litigated against basically a non-existent legal backdrop. There are no precedents at all in Europe about what the damages are in a securities case. So the plaintiffs aren't just using the narrow American formula, the out-of-pocket formula in securities cases. They are making arguments about rescission or even benefit of the bargain, and because there are no cases, you can go back to old contract law norms and talk about what might need. There are going to be lots of issues, and again, I'm not predicting whether we're going to see general patent take over all of Europe or whether we're going to see Waterloo creep up, but we're coming to that point where globalization has begun to reach Europe, but without the class action or the contingent attorney's fees. One last slide for when we're all done and we turn to this topic. All right? On that note, I'm going to turn the floor over to Sam Issacharoff, who's going to give you a general theory. No questions at this point. Questions will come at the end. I'm going to take Sam giving us a general theory of how to solve everything.
That is my title, if I can get it up here. It doesn't here. Can you hear me? All right. So the unified field theories are always popular, and universal fixes are a good thing. So I'm going to combine both in 10 minutes. The argument goes as such. Most of the scholarship and almost all the case law that deals with aggregate litigation is siloed. That is, it tends to address the particulars of a certain kind of aggregation and tends to miss the fact that there's an interactive effect between multiple sorts of litigations. And so occasionally you get an opinion, Judge Sirica in the Sullivan case or in combustion engineering, comparing Rule 23 to non-Rule 23 aggregations or Rule 23 to bankruptcy. Occasionally you get comparisons in the scholarship between one or another kind of aggregation. But generally we tend to have articles, Howie talked about high agency costs in class actions. Beth's written extensively about high agency costs in MDL proceedings. They tend to stay within one and miss the interactivity among different kinds of litigation aggregation devices, which my argument is, it's an argument, it's just an observation, that the combination of social media, increased capital market interest in this area, has made the movement across all of these much more significant than it had been. Well, let's see. Okay, so sorry about the small font. So I want to suggest that there are 5 kinds of aggregations. Is this a pointer also? Wow. If we look across the top, I could have included bankruptcy also, but I basically want to say we have the formal aggregation under Rule 23. We have less formal aggregation mechanisms. The MDL I consider less formal because it doesn't join all the claims as such. It just organizes their administration. You have informal lawyer aggregation, portfolio of cases held by plaintiffs' lawyers of related proceedings. You have the new player on the block, which is finance aggregation, which is aggregation created by funding sources who are able to overcome some of the legal barriers to aggregation. And then you have public aggregation that Maggie Lemos has written extensively about through AG's offices, through the FTC. If we go to the Volkswagen litigation, you got EPA in there, you have state administrative agencies, you have state AGs, you got the whole range of players. And then if you look at the literature and the cases, you'll see that there are 4 basic areas of concern in each of these types of aggregation, and they are the separation of the legal claim from directional litigation, what Jack just mentioned as separation of ownership and control. You have the problem of what's the expected recovery from this type of litigation. You have the legal ethics problem, which occupied the last panel. And you have the question of whether or not they're promoting the public interest, whether it's, as Alan Morrison says, the problem of deterrence, but in some fashion, whether the public objectives of law are being met. Now, if you just take the first one, separation of legal claim from directional litigation, anytime you have a gap between the ownership of a good and the administration of that good. You have what the economists would refer to as an agency gap. And the greater the gap, the greater the potential for agency costs, the more difficult the monitoring becomes. And so we have a lot written in the first column on class actions. You can go back to Derek Bell's argument of, God, it's almost 40 years ago, on serving two masters and the separation between the NAACP Legal Defense Fund and the objective of local communities. You can go to Jack's pioneering work of 30 years ago on using the same principles of managerial autonomy and agency cost from securities law, from securities proper to securities litigation. That move was a defining feature of understanding the problem in class actions. But it turns out that this exists across all of them. We've heard today about agency gaps in MDLs. We can talk about agency gaps when the public attorney general represents you, who has a constituency that is different from you, may not have your interests at heart. And so what we find is that the concern in the literature and the cases on each and every one of these is the problem of high agency costs. And it turns out high agency costs are reproduced across all of them. Then when we get to the next column, which is the expected recovery from litigation, again, we've most extensively dealt with it in the class action, but we know, what do we know about class actions and expected recovery? They're too high, right? Class actions are extortionate, tells us Judge Posner. They are a means by which wealth is transferred from innocent defendants to greedy plaintiffs through this costless aggregation. And they always result in too much money being paid, except under one circumstance. We also know that they settle for too little. And so there's not enough money being paid. And the great thing is that we not only have Seventh Circuit law that establishes that they always get too much, we have great recent cases from the Seventh Circuit that they always get too little. And it turns out that that seems to be reproduced in the academic literature, because the academic literature is divided between class actions get paid too much and class actions get paid too little. There is no known documented example of a class action getting it about right. It just doesn't happen. And then when we go across, and I'm not going to go through all of them, but let's just pick one, finance aggregation. Finance aggregation, all of a sudden you have this pot of money. You have hedge funds from Connecticut investing in litigation. They're going to pour in all this money. They're going to make claims worth something that previously were not worth anything. That's paid too much. But if you go and look at the actual litigation funding contracts, they're almost invariably payout on first dollars. And so the incentive structure in these contracts is to settle quickly to get the recovery and to get cash flow over the volume of transactions moving as quickly as possible, so that the hedge funds coming into the capital markets coming in have the same, reproduce the same problem that we saw with class actions, which is that they always settle for too much, except that they also always settle for too little. And so it turns out that if you go across, you have the exact same problem in every single source of aggregation. Legal ethics, oh, this is a disaster, right? Because the lawyers, if we go to class actions, we can go back, trace the Third Circuit case law. You start with Judge Adams, who I clerked for in corn derivatives, and you move on to Judge Becker in lazy oil, and we find that you just can't take normal legal ethics and move them willy-nilly into the class action domain. You have to have something to mediate for this kind of different sort of representation. And so we worry, what are the ethical constraints on lawyers representing an aggregate? All of a sudden, there's not the same kind of client control. There's not the same kind of judicial oversight, because it's just too big a case for the judges to be able to monitor what goes on. Well, then when you look at the literature on the MDL process, you see the exact same critiques being put forward, that all of a sudden the lawyers at the top, that was Bill Rubenstein's provocative argument today, the lawyers at the top have no connection to the client they're representing. So we have a divorce of the attorney-client relationship in a way that compromises the capacity of the normal rules of professional responsibility to constrain lawyer behavior. And the flip side of Bill's presentation earlier is that Judge Roof in Philadelphia has very little knowledge about the individual circumstance of this client in Kansas, of the one client in Kansas who never filed in her court, who never appeared in her court, her lawyer never appeared in her court. So now you have a gulf there as well. And if we went across, take for example, public aggregation, well, there all of a sudden, who does the AG represent? Doesn't represent me as the consumer, they're representing the aggregation of claims. Sometimes they take the view that all the money should escheat to the state. How does that help me, right? How is that working on my furtherance? Now the lawyer for the state, like the other lawyers, may be demanding too much because they have the huge power of the state behind them, but they may not be interested in compensation to me. For all we know, the AG may be running for governor or senator, they always are, and so may need a press conference on the quick, much more than they need actual last dollars returned to me. And so what you find is that there is a lack of direct court and client oversight that goes across all of these categories of aggregation, regardless of which one we're working in. And finally, the public interest. Are we getting deterrence? Are we getting the right amount of furtherance of the social objectives of the underlying law? And here again, not surprisingly, it's uncertain. It's uncertain because the individual is fundamentally because the individual is not in control of his or her claim. So let me finish with 2 points. I know you all want to see how I'm going to fix all this in the last 30 seconds, but you'll have to wait a second. So let me finish with 2 points, one being the fixed, second, and the first one being a little bit more serious. The more serious one is that these are all the product of exactly the same impetus in social organization. You have mass harms, you need a mass resolution. The mass quality of it means that you have to empower the agents. The agents mean that you have to have people who are willing to take up the cause and who are willing to either underwrite it, take the risks associated with it, in most instances seek to recoup the rewards associated with it. And under those circumstances, it turns out that these are not alternatives. These are fungible means to the same exact end. And so we go back, for example, to Judge Sirica's opinion in the Sullivan case, where hopefully I'm not distorting it because I have to answer, but the basic point was, wait a second, we're driving up the requirement for class certification too high. We have pushed things out of a domain that may be better suited to this kind of problem and now pushed it, in that case, from formal aggregation into completely informal lawyer aggregation of portfolio of cases. We heard Judge Rubino today talk about the winding down of the MDL dealing with asbestos, a very important development. There was one part of the talk, though, that I thought was missing. And that is, how come we could wind down the MDL and asbestos? It's because we moved all these cases into bankruptcy trusts. And so we have used an alternative aggregative forum to deal with the compensation side of these cases. So we've taken the federal judges out of the business. Why? Because we don't need them. We found somebody else. And so that's where the fungibility comes in. So how do you fix all this going forward? If you accept my premise that what's the wave of the current and what seems to predict the immediate wave of the future is a lot of mobility across these different kinds of categories of aggregation, what's the fix that helps us get a handle on this? Well, I think it's got to have 4 components. It's got to have a reduction of agency costs. It has to have the ability to get the amounts paid, the compensation, closer to what we think is socially ideal, contested concept, socially ideal. It has to reinforce the concepts of professional responsibility, most clearly when bankers and other non-lawyer folks come into the picture, and it has to be geared to promote the public interest more effectively, which yields the obvious solution, so obvious it's shocking nobody's put this together before. Lower agency costs, get the right amount of recovery, more ethical behavior, and protect the public interest. That's a simple 4-point program. I'm ready for office. Thank you.
Thank you, Sam. That was provocative. We're now going to go to Margaret Lemos, who's going to be on her familiar and favorite theme, the role of the government in aggregate litigation, and it's an important topic. Margaret, the floor is yours.
Thank you. So I'm gonna stick on the fourth column of Sam's inspiring chart and talk a little bit more about this possible future for group litigation, and that is group litigation that's handled by the government. And so we could have a state AG suing on behalf of her state citizens and seeking financial recoveries that will then, in theory at least, be distributed to injured citizens. We could have an agency like the FTC doing the same sort of thing at the federal level. And what's interesting about this kind of suit is that it puts the government in the role of seeking what are conventionally thought of as private interests in compensation and seeking remedies that we could imagine private citizens seeking on their own through a private class action or otherwise. Now, I haven't tried to prove this empirically, but I think it is safe to say that we are seeing government do more of this these days. And some observers have suggested that that's a good thing and that this role for government might help fill some of the gaps that are being left by the disappearing class action. And so I want to focus on one particular line of argument in favor of representative litigation by the government, something that is typically thought of as an advantage of government litigation. And that's the idea that one thing that makes government representative litigation more attractive than private class actions is that government is accountable. Accountable to the people, politically accountable and likely to reflect the public will in some way. Now, on one view, that's a very attractive picture, I think, of group litigation. All of us in this room, I think, can appreciate the litigation can be a very powerful thing. At the very least, it can make lots of money change hands, but it can also really deeply change the behavior of regulated entities. Litigation or law enforcement more generally can have significant consequences for what the law actually means in our lived experience. And so it might seem only right and good that it be in the hands of accountable officials, or that it be responsive to the public will in some way. And I think accountability also could look good, at least at first glance, from the perspective of the more discrete private interests that are implicated in group litigation, something that we've been talking about a lot today. We all know that it is very difficult for the clients in aggregate litigation to monitor what their attorneys are doing in their name. And so we worry a lot about potential conflicts of interest between attorney and client. When we're dealing with government attorneys, I think it might be tempting to see those concerns receding, at least a bit. Because government attorneys, after all, can claim to be representing their clients in not one but two senses. So both in the familiar attorney-client sense, but also as political representatives. Government attorneys are not out to make a buck. Their salary is not going to be affected in an immediate way by the outcome of any given case, and they are duty-bound to serve the public interest. And so from the perspective of the individuals whose interests are in stake in any given case, injured consumers, for example, government attorneys might seem like truly ideal representatives. And we can see that kind of intuition reflected in some judicial opinions. I won't go into detail here because I want to be quick, but when dealing with questions including whether or under what circumstances private actors can intervene in government actions, whether a class action is a superior method of adjudicating the issues when there's also a government action pending or might be pending, or when assessing the adequacy and fairness of government settlements, it is not hard to find judges expressing this intuition that government is the ideal representative of citizens because government attorneys are supposed to be serving the public interest. And so we just don't have to worry as much. We can trust these attorneys without quite as much oversight that we might think was necessary in a private action. But I want to suggest that there is actually a lot to worry about here, as Sam's table suggests. And importantly, that is true even if we trust government attorneys completely. And the core of the problem, as Sam suggested, is that the public interest that government is obligated to serve in a representative action or in any action is not the same as the private interests that might be at stake. The public interest includes the interests of defendants, of potential defendants. It includes the interests of citizens who just think this particular law is silly, or that the government just shouldn't be wasting its time and effort on this kind of case. And so one doesn't have to cast aspersions on the dedication or skill or professionalism of government attorneys in order to see the potential for a conflict between these two interests that government attorneys have to be serving in these sorts of cases, the public interest on the one hand and private interests on the other. So to take this back to the idea of accountability, to the extent that government enforcers are accountable to the public interest, or that they can claim to be political as well as legal representatives, it's not clear that that's actually a good thing for the private interests that are in stake in litigation. But I also want to suggest, and this is much more tentative, this is something I'm working on now and still haven't quite figured out, I want to suggest that accountability is not necessarily a good thing from the perspective of the public interest either, or from the perspective of the legal system as a whole. And so the idea here is that when government is making decisions about enforcement, about whether to go after a particular defendant or what sorts of remedies to seek in any particular action, it's making a judgment about how the existing law should apply or does apply to an identifiable individual or firm. And that sort of decision has some features in common with decisions that we might think of as adjudicative in nature. And when we're thinking about adjudicative decisions, accountability isn't generally at the top of the list of values that we're trying to promote. So when we talk about judges, for example, accountability is at the very least a contested question, political accountability. And I think it ought to be for these sorts of litigation decisions as well. That is, it strikes me as at least unclear that accountability in the conventional legal and political sense is normatively desirable when government is acting in this representative litigation capacity. If nothing else, I think something important would be lost to our legal system if all enforcement decisions were subject to majoritarian checks and majoritarian forces. Now, maybe it all works out nicely if we can have public litigation serving majoritarian ends and private litigation serving more minoritarian interests. But if that's true, it suggests the need for real caution before we embrace the idea that government can sort of act as a substitute for private actions rather than serving very different interests. Let me stop there.
Okay, we've got 22 or 3 minutes left. 10 of these at least will go to Judith, and then the rest of you will have your chance for the remaining 12 minutes to penetrate through all of the stuff we've thrown at you and get to the real merits. I give you now Judith Resnik with no further introduction.
Except I need the single screen coming your way. So how in the waning moments that we all won't die sitting still, I thought I'd try 4 points in 10 minutes with 10 slides to start, and it seemed appropriate on this occasion to start with Ben Kaplan. He was speaking on the 50th anniversary of the Federal Rules of Civil Procedure in 1989. He, of course, is the drafter of the multi-party rules in the 1960s. So since we're coming up on the 50th anniversary of the Rule 23, which has been the framing device for our thinking about aggregation, it seemed to go back to Ben Kaplan was the appropriate route to take. And I picked him both, therefore, because aggregate litigation is embedded in litigation itself, and Rule 23 is very much a part of the Federal Rules of Civil Procedure. And so to think about the future of group litigation is to think about the future of litigation itself seriously. And then in looking at what it was that he described, he was very clear that that project was as rule-laden, as substantive as any of us proceduralists could call it. There was a plan. We would today call it enabling litigation. Since the word claim suppression has been used a lot, I'll call it claim expression, because the goal was to enable people to bring lawsuits. And he identified two of the key techniques as discovery and as class actions. And he described the opponents of those techniques, in his words, the scourge of corporate and governmental malefactors. And so he was seeing a value system that he was in 1989, on the 50th anniversary of it, praising. Of course, it was deeply embedded. The rules are never solo actors in a value system of federal statutes like the Legal Services Corporation, of fee shifting, as a part of this idea of courts as real sources of remedies. The actually really amazing part was the reinvention of courts, which had long been not courts for all the poor people who could inhabit them, for all the people that Judge Kuehl was describing, thinking that this is a place for them. Some of them are dragged in, but some of them are volunteering, is a minor miracle of the 20th century creation of courts as service providers there. And so here is the kind of creation. It intersects, because actually, although the class action rule got all the heat, the sleeper of the story was the 1968 MDL provisions, which were just seen as managerial efficiency, but of course, once you're efficient, you want to enable, and so the two things interact as well. And so the reason to start with Ben Kaplan is both to admire him, but also to see that although it's 1989 and he's celebrating, we're actually at the cusp of the end of the centrality of the federal rules of civil procedure. And this whole day has been a tribute to the multiplication of sites and spaces for aggregation, to their variation, your wonderful grid in terms of these options here. And so if point one is looking back at the value system that was and that exists and is actually moving out of sight, point two is going forward. We're looking at a world of pop-ups of aggregation all over the place, de facto, de jure, and the like. We're looking at tens of hundreds of mini rules of procedure that are being, I call them alternative civil procedure rules, ACPR, because they're all over the place, and I'll give you I'll give you some examples of them. One version is adjudication is so useful that it's being repopulating in so many other places. Prisons have mini court systems. Schools and universities, the ALI project on sexual misconduct. We're looking at this idea of the project of it, so isn't it wonderful it's just spawned everywhere? Well, it's wonderfully spawning maybe, but it's expensive, it's complicated, and it's hard to figure out. And so here's, this is in fact my cell phone, it's still a BlackBerry, and this is the document that came with it, and the document that came with it, they said, keep it safe. It's a terrible graphic. All the people here will tell you it's terrible. You can't read it. It's terrible. It's a great graphic. You can't read it. You can't negotiate it. There's no point in reading it. I'm putting it up here because I think icons are important. And the reason to look at it is to realize that what it is doing is, if we were talking about aggregation, disaggregation, we could talk about it as dismembering group litigation. It is an ex-ante preclusion of my participation. It very dearly also says that AT&T can't sue me as a class, which I greatly appreciate. And then Ted Rave has a great essay that talks, this is an ex-ante waiver, there is an ex-post waiver. The TransUnion case about the Fair Credit Reporting Act settles with preclusion of aggregation. You can still bring single file cases, but you can't bring them as a group. And that's the ballpark, is the centrality and the utility of precluding aggregation there. So ex ante or ex post. I think it's important to look at the record in the US Supreme Court when the AT&T case is pending. At the time, there are about 70 million people who have cell phones with AT&T. At the time, there are fewer than 600 that have used their mandated arbitration system. At the time, the American Arbitration Association has the capacity, actually then as now, it does about 1,500 consumer arbitrations, 1,500 consumer arbitrations. AT&T, this is Judge Hellerstein's point, does adjust some of the billing complaints. And at the time, there are 224 class arbitrations on the docket. What do we know? We know, of course, that California says we won't enforce this, that the Supreme Court says it's preempted. And so there are two justifications. One is consent. This is the document that is on the web now. It says AT&T can unilaterally do whatever it wants. So I keep calling it a document and not a contract, because a great essay by Arthur Lieff at Yale Law School talked about the contract as thing. It's not bargainable, it's not bargained, it's a product, we'll regulate it or not. This is not a contract. This is my document that I got. When I got this, I got a dispute resolution and some other buttons with it. So consent doesn't justify it. The other great explanation is that this is an effective mechanism for vindicating, because now we're anti-court. It's better than courts. It's cheaper, it's efficient, it's better, it's better, it's better. We sadly heard Judge Hellerstein say the good part of his settlement was that there was no trial. So this is a view that the no trial is a good thing. So on the no trial, this is the effective, efficient. What do we know? Whoops, we went too far, sorry. What do we know? Okay, so with fabulous law students, we combed the 17,000 document entries for the American Arbitration Association, which is forced by the state of California to provide information on its consumer arbitrations. It complies. A lot of those, I said forced, actually it's a complier. A lot of the providers don't comply. And what we figured out is that AT&T had between 70 and 110 million customers each year for a 5-year period, and fewer than 30 ever filed an individual arbitration claim. So there are a mass number of obligations to arbitrate, clauses to arbitrate. There are not a mass number of arbitrations themselves. And our data, which is up at the top level, comports with the Consumer Financial Protection Bureau, which, scoring a whole bunch of other documents found in the American Arbitration Association's database, 616, but 2/3 are brought by the companies against the individuals. So individuals are not bringing these. And to the extent we think of this as individual access, that is not enabling it at all. So then, of course, the question is why? And one answer is company adjustment. And a second answer is no need, because the companies are so compliant. And the problem there, which will go to Maggie's government enforcement, is the FTC and the FCC brought lawsuits against all of the major wireless providers for what's called third-party cramming. We got $10 extra every month for some service we didn't want. We called up and complained, and they did adjust, but only 1 or 2 months or not at all. And it turns out that state attorney generals and the U.S. government file, and within a month of the filing, everything is settled, and they're redistributing money to us because they were overbilling us across the board. So the no-need explanation is not a persuasive one for the absence of filings. What is persuasive is the desperate need for group-based resources for equipage. And aggregation is one form of equipage. And the other part of the Consumer Financial Protection Board is it told us a lot about how group litigation, your entrepreneurial litigators, and maybe some of your categories, intersect with government litigation. Government litigation often comes after private filings, not before private filings along the way. So if point one was the past had a set of values about trying to get us into court and equipping us to do so, and the current is about disaggregating and diffusing disputes to these gazillion little pods, and they're so hard to figure out. I have to say the other reason it's hard to bring claims, one is the economic, it's not worth it part. It's actually hard to do. So I'm sitting there in my office with smart law students and me, and something says consumer dispute resolution, American arbitration rules, and then something else says wireless rules, and something else says commercial rules, plus whatever documents you have say some other things as well. This is not the new style project that Lee Rosenthal managed for the Federal Rules of Civil Procedure. This is actually hard stuff to read and figure out where you're supposed to go and how you're supposed to do it. And by the way, on fee waivers, California requires fee waivers if you're indigent. And if you knew that and you looked on the web, you'd find a form from the American Arbitration Association. And DC does as well, but the form says for California users only. And everybody else, it's not on the web, but you can call them up and you can get a form that says defer or reduce your fees. But you'd have to call to know. And although the companies, as we know, are wisely advised by many lawyers and provide waivers or fee reimbursement after the fact, they don't do the ex-ante filing so that it costs money to file the $150, the $250, the filing as well. Now we move toward the near future and the far future or further future. Close future is there's reform potential depending on the election. And one is the Consumer Financial Protection Board says we want to limit some of the use of the class action waivers and we want more information around them. Another version is that Medicare and Medicaid say, you know, when you sign Antilly in, you really shouldn't waive all forms of redress inside court systems. And so there's been negligent death claims that are mandated, arbitrated, and you may bust them. By the way, individually, you can bust some of these through individual litigation under state contract law, but that is so expensive and so inefficient along the way. So the next step is that on the near end, you sent us to Europe, And so it's worth looking at Europe, but this is a different thing. We haven't talked much about technology and ODR, online dispute resolution, which is popular. eBay does it here and some other companies. In Europe, there's a directive for the European Commission that is trying to be market friendly. Why does Europe want to do that? So when I buy this in the Netherlands and then I breaks in Italy, I have a dispute resolution mechanism and I don't have to travel. But the key thing to understand about this online dispute resolution, which is claims expressive, file your claim, is this provision, which says the right to an effective remedy is fundamental. It is not designed to replace. It is not designed to preclude. It is not my cell phone that precludes, but rather a possibility. Now, in reality, most of the stuff washes away because it is a small value claim and it is dealt with. It also requires, by the way, the European directive requires reporting and databasing and information and certification and some of these other things as well. The description is a pathway to justice along the way. So this is the near term is, will there be changes, and if so, how? I tried to get data on eBay that was systematic. You can scratch around, but it is not public information. And so one of the key facets is that we are having this discussion with a set of amazing descriptions of litigation and observations over the last day because of the information required notion that whether you call it accountable or not, courts have to provide you with information, holding aside in the problem of confidential settlements that's coming around my corner. But this idea of courts as information providers is tremendously important for us to be able to fight about what we think the rights and remedies should be. So now let's go toward the future. And this is trying to do 100 years of federal court filings. I'm sorry, I'm federal-centric for a minute, but I'll get to the state courts in a second. And on the federal side, basically, filings are flattening. Now, from some people's perspective, this is great news. Filings have gone too high. We don't want them to go high. We want them flattening. Depending on whom I've talked to in this room, you're less busy if you were a judge than you were 10 years ago because, in fact, fewer people are filing claims and being able to bring them. And then, of course, the next slide is a class action to DeKalb County, Georgia, which is a settlement, which is to say about fines and fees. We think of courts, Tom Tyler was talking about as courts and vindication and public confidence. This is a hard-to-read document that is telling judges to read it up close. It's called the bench card. When you are dealing with indigent litigants facing criminal defense, you're supposed to tell them that they do have a right to a free counsel, and even if they're charged $50 afterwards as a fee for that free counsel, if they can't pay it, they're not supposed to be threatened with going to jail. And a few weeks ago, the Department of Justice sent a letter. There's an office called the Access to Justice Office in there, which is staffed by a former state court judge, Lisa Foster from California. And it says, judges, court systems, chief judges of all these systems, please tell your judges at the trial level to stop threatening to lock up people who are too poor to pay their fines and fees. This was Judge Kuehl was talking before about the state court system. This is a flash of the criminal side, but the National Center for State Courts has a recent document that looks at 1 million cases in 10 jurisdictions and basically finds that in 80% of them, one party is not represented in court in cases. The last I knew, California had 4.3 million and New York 2.1 million people in civil litigation in court in cases without lawyers along the way. This is a cri de coeur for us to be worried about the problems of equipping and staffing. And in the National Center for State Courts, which fits some of Sam's grid and some of the discussion, it's management. There's almost no adjudication. So one is that the last 50 years have produced a system with some pods of huge amounts of aggregation that makes it look vital and booming and terrific and people are doing well. The 1% luxury good. Millions of people, 100 million people go to state court every year filing cases looking for forms of remedies, and a vast number of them have very little equipage. So what's the finalization here? Question, do we want adjudication 100 years from now and courts to be vital social services in which we enjoy the idea that the government is responsive individually as well as collectively? If we do, aggregation is an absolute must for the purposes of this. Different forms of aggregation, but it's an absolute must. And why would we want this? The so what? This goes to the question of transparent conversations about conflicts about rights and remedies. And I'm just going to end by mentioning Spokio, which is about the Fair Credit Reporting Act. And the question is, should that be a cause of action? If so, for what damages and what remedy, through what mechanisms and the like? Congress has said there is such a remedy. Some people think there shouldn't be such a remedy. How are we going to debate that? The side settlements and the confidential settlements, whether they're coming out of GM or they're coming out of others, prevent me from figuring out which side I'm on in some of these, and we're all on different sides in this. And so what courts can offer is an incredibly civilized way to have painful conversations and conflicts over resource distribution, and without a future that includes robust but regulated arbitration. So on Sam's slide, fix it, we need regulation of all of these issues. Even if we're wrong, we need to try it and then try something else because we can fight about what the next should be. And without that, the future of adjudication looks sadly bleak.
Okay, thank you. We have 5 minutes, which gives us an opportunity for a few short questions or one very long one. Who will be first? Hands up. Linda Molnix is back there.
Thank you. I would just like to address myself to your presentation about the Napoleonic invasion of entrepreneurial lawyering in Europe. And I have 2 questions that are almost in the form of comments. Your slide presentation basically described the VCOM procedure in the Netherlands. And unless you believe that the Amsterdam Court of Appeals is going to be the tail in Europe that's going to wag the European dog, I think it's something of a stretch to talk about this invasion of entrepreneurial lawyering in Europe. And what was not in your slide presentation, in 2012, followed in 2014, the European Parliament basically promulgated a set of principles for collective redress mechanisms in the EU. And then they issued a recommendation in 2014, which will become a directive in 2017. And if you go through both the statement of the principles as well as the recommendations, the litany of what's incorporated in that just rejects every possible feature of American class action litigation. And so what the EU did was basically said to their member countries, if you're going to put into place collective redress mechanisms, they can't have contingency fees, they have to have a loser pay rule.
Can we get some other questions and statements in, Linda?
No punitive damages, no American-style discovery, must be an opt-in.
Well, I'm glad I included that last cartoon because we're seeing it.
Okay, but my point is, the EU directive, okay, will go into effect for all the EU members. And so the question is, what then is going to be the state of collective redress mechanisms in EU once the directive goes into effect?
All I'll say is they're not purporting to use the class action mechanism. These are private actions in the rest of Europe, consolidated actions, and they propose to settle them pursuant to an existing Netherlands statute that permits a settlement class. And they have at least seemingly done that so far. I don't predict the future. I'm saying we've seen the invasion. And I can imagine that the empire will try to strike back in all kinds of ways. But I'd like to get at least 2 more questions. Over here, Richard.
My question is quite narrow. I think it is directed to Maggie Lemos and Sam Issacharoff. We both talked about public policy. Aren't you talking about something different? Maggie Lemos seems to think it's just whatever publicly elected officials want. I take it, Sam, you're talking about something that you conceptualize differently. I'm interested in whether you're really talking about the same thing.
In 2 seconds, I'm just talking about the general objectives of law, which is something that we all agree about.
I agree with that.
Last question. Anyone? Our last question. If there is no last question, I will hereby declare these. Oh, is there a question over here? Richard? I'll turn it back. Oh, Richard, I'll turn it over to you to close proceedings.
Well, thank you, Jack, for chairing this session. Thanks to all of you for having been such terrific panelists and such a terrific audience. And again, congratulations and thank you, Beth, for having provided us with a reason to get together and to discuss these issues. And being the late person in the room, I learned a lot, and I hope that everyone found it to be a worthwhile day. Thank you so much.